So there is yet another chapter to the Malibu Media versus William Mullins case that we've been following for several months now. Malibu Media is one of the, if not the largest copyright troll in the history of new copyright litigation. Between 2012 and now, they filed almost 9,000 federal copyright lawsuits. Strike 3 Holdings is catching up to them quickly and is probably the bigger copyright plaintiff, but Malibu Media was the one that sort of had the, for lack of a better way of saying it, kind of a blitzkrieg of new copyright litigation over BitTorrent file sharing piracy. Well, Malibu had a great thing going for a long time. They won their first case back in 2012 or 13, the bellwether hearing that started my career, basically. And I defended people from Malibu and then Strike 3 Holdings for a long time, for the last 10 years. And I'm currently defending people from the same kind of case in Strike 3 Holdings issues. Well, Malibu, something happened. Something happened to their company. Something happened with their owners, Colette Pellissier. Her maiden name is Colette Leah or Colette Lay. Her husband is Brigham Field, and they started XArt, a adult-oriented entertainment website that I'm sure people have, they know what the internet is for. And they would then sue people that they caught file sharing their videos on BitTorrent. Well, the only way to track that activity is to be part of the BitTorrent swarm, the peer-to-peer file sharing network that's created for sharing any one file by the BitTorrent protocol. And that's just IP addresses. So she and her company would sue people based on IP address, and they would accuse usually the subscriber, but sometimes it was somebody else. They would accuse them of copyright infringement based solely on having seen activity on an IP address. And they would assume pretty strongly that if you were an internet subscriber, you were likely to be the infringer, just because you were a subscriber, and not always with extra evidence identifying one individual person. Well, Malibu doesn't always win every case. These plaintiffs don't win every case because not every internet user is a infringer, and not every internet user is the infringer in a Malibu or Strike 3 case. So in William Mullins' case, when he was accused of copyright infringement via BitTorrent peer-to-peer file sharing, he defended himself, and Malibu could not produce evidence of his infringement, or maybe they chose not to. And his case was dismissed. And in getting dismissed, William Mullins was the prevailing party. And by being the prevailing party, you can ask the court for your fees and costs. So initially, the judge entered a order for a $48,000 judgment. And we covered this, and I covered this in several videos that I've done on this topic so far. And the judge enters this judgment, but then Malibu Media doesn't pay. So William Mullins and his attorneys, they hire a collections attorney to go after the money. And in trying to hide money, trying to prevent the collection, Malibu Media and Colette Pellissier made it more than doubly worse. It went from a $48,000 judgment to a $108,000 judgment, which was just now able to be collected in full. At the last hearing, the last video that I did on the subject, Colette had sent a crazy letter to the court, basically attacking the case from the beginning, that William Mullins was somehow guilty of this infringement, even though she couldn't provide any proof of it, that the Peacock law firm, the collections attorney, was being too hard on her and was not accepting her settlement offers, the perfectly reasonable settlement offers. So we went over this crazy letter. Well, the court held another hearing when the collections attorney went after the last $17,000, which the judge had suggested maybe don't go after the last $17,000. It's just a pain in the butt. But they went after it anyway. So William Mullins' collection attorney asked for a discovery of assets when he noticed that Malibu switched their collection of their money from Epoch to CC Bill. So one of the problems you have with adult entertainment companies is that credit cards are often used fraudulently for paying for those services for whatever reason. And so a lot of credit card companies don't want to deal with individual entertainment companies. So you have these intermediaries, CC Bill, Epoch. I'm pretty sure there's others. But what Malibu had done, Malibu had been getting paid through Epoch. Then Colette switched the Epoch account over to her husband's Zio Digital account so that the money would go through Zio Digital instead of through Malibu Media. That didn't work. Epoch had to turn over all the money directly to the collections attorney. Then Epoch, after all of this, no longer wanted to do business with Malibu, so Epoch pulled out. Malibu and Colette get CC Bill here, as you see here on the screen. They get CC Bill to handle the credit card processing now, and now the collections attorney has gone after that. Well, on April 20th, there was a hearing on this, and at that hearing, no one appeared on the call to object to the motion for a turnover. This is what happened last time. Colette doesn't appear on the call for some reason and then sends a crazy letter. Now, something you should know, one of Colette's common complaints is that she's not allowed to have an attorney. She is allowed to have an attorney. She just hasn't asked for an attorney using the proper motion that she's supposed to do. She has formed Malibu Media as an LLC. You don't automatically get an attorney for an LLC. You can't represent the LLC. So Malibu Media hasn't really been represented since their attorney left after all of Colette Pellicier's shenaniganery. So the turnover order then gets granted. Malibu Media versus William Mullins, directed to CC Bill for $17,635. The court finds that the court originally entered judgment in favor of Mullins and against Malibu Media for $48,656.73, plus interest and costs. On April 20th, 2021, the clerk of court issued a citation to discover assets directed to Malibu and its designated corporate representative, Colette Pellissier. When Pellissier failed to abide by the citation, Mullins obtained an asset restraining order from the court. The asset restraining order defines XArt proceeds as the proceeds of the XArt website's commercial activity. This court subsequently issued a declaratory ruling finding, among other things, that Malibu Media is the fee simple owner of the XArt proceeds, and two, by virtue of the citation to discover assets, Mullins has an execution lien on the XArt proceeds to secure the payment of his judgment. By two turnover orders directed to epoch.com, the original judgment of $48,656.73 was satisfied in December of 2021. On November 29, 2021, this court entered an amended judgment in addition to the original $48,000 judgment in favor of Mullins, jointly and severally liable against Zo Digital, Malibu Media, and Colette Pellissier for the attorney's fees of another $59,614.52. We'll just round it up to $60,000. The amended judgment consisted of statutory civil penalties assessed against those parties for disobeying the restraining provision of the citation to discover assets and disobeying numerous court orders to produce asset information. They tried to hide assets. This is what happens when you try to hide assets. February 28, 2022, the court granted Mullins' motion for a turnover order directed to epoch.com for another $42,000 in XArt proceeds. Epoch, who terminated its relationship with Malibu Media, complied with that turnover order and thus reduced the amended judgment to $17,635. On March 29th, another citation was issued to discover assets to CC Bill, an Arizona limited liability company that processes credit card transactions. On March 30th, Mullins caused the citation to be served on CC Bill. Mullins also provided CC Bill with copies of the court's restraining order and subsequent order, which found the XArt proceeds to be the property of Malibu Media and therefore subject to Mullins' judgment. April 11th, CC Bill answered the citation. They had proceeds totaling $24,000, which will cover the $17,600 balance. They stated that there are no prior garnishments or other court-ordered withholdings. Therefore, it's hereby ordered that the judgment creditor's motion for a turnover order directed to CC Bill is granted, and CC Bill is directed to turn over the 17,635.04 to Mullins to the Peacock Law Group Client Trust Fund account. Then the court posts another letter from Colette. So this was posted shortly after that hearing was held and the motion was granted. She says, "I was not able to be heard at a hearing today," in quotation marks. And she's attached some things here. Peacock rejects full offer to Mullins. Northern District of Illinois, April 20th docket, something missing from Pacer. Mail, Colette Lay, which is Colette's maiden name. Outlook Mullins. Fraud upon the court. How to disqualify a judge PDF. Field Malibu versus Mullins misspelled declaration.pdf. Interesting way to start. It says, Emily Judge Kirkin, his name is Judge Durkin, and ladies and gentlemen of the court, the Hollywood Reporter, the New Yorker, and the Chicago Sun-Times, more to come. This hardship demands a new hearing. She's been demanding a new hearing because she doesn't feel like she's been represented. But the thing is, she's got a company, and the company's got to be represented by a separate attorney. So she gets her own personal attorney, and then she gets an attorney for the company. She hasn't done that. The absolute horror and depths of corruption in the Chicago court demonstrated in the raw by disgraced Illinois Department of Justice collector, the guy who makes sure everyone goes broke. He collects on people who will owe for their entire lives, even though this judgment is satisfied like now already. And he uses the long arm of Illinois draconian collection law to bring in other states and ruin small business in the midst of COVID and the aftermath. The full faith and credit clause of the Constitution is what allows states to share judgments with each other. You will even see Attorney Durkin insisting on $60,000 in fees, and the government told him he was excessive with $10K, as agreed to arrange a plea deal to put someone in jail. No one went to jail in this case. This was a civil case, so I think she's mixing up when he worked for the Department of Justice versus when he's now a private collection attorney. Also, the attorney's name is Stewart. The judge's name is Durkin. Judge Thomas Durkin. My first contact with Durkin/Peacock was Peacock adding supplemental proceedings to a closed case, see Westlaw. See Westlaw. See all of Westlaw. Just go to a Westlaw terminal and look at it, and you will see what she's talking about. And the first day I spoke to him, he said on the record and sent hundreds or thousands of letters to my colleagues and friends, forced my entire team that I trained for 12 years to leave. I don't think he forced your team to leave, no. They were told that if they were paid even $1 from me, they would be in criminal contempt. It sounds possible. If there was a court order and they violated the court order, you could be in contempt, yes. But she's like skipping a lot and going straight to, this is corrupt because someone said the words criminal contempt, with no further explanation. Judge Durkin had an ex parte meeting with Joe Stewart. Okay, so now she's got the parties right, the judge's name and the attorney's name. You will see the sealed and unsealed versions. And after that, quoted a known felon who was trying to extort me. No name on the felon, but added I was in criminal contempt for not letting him steal more from me. Again, no name on this purported extortionist. That lawsuit will be linked also. This goes so much further than that. Durkin told me if I did not go to Chicago in August during COVID with all the violence, he would send federal marshals to have me arrested. No, I mean, I think there was an arrest threat if she didn't show up by telephone. This is after we offered to pay their $42,000, which we never owed in the first place. I think it was 48 that she owed in the first place, or 46 that she owed in the first place. So if she offered to pay 42 and he didn't accept it, that's fine. Hey, if she offered to pay the 48 and he didn't accept it and went through this anyway, she can argue that maybe she shouldn't owe additional attorney's fees because she made a good and valid offer, but so far she hasn't done that. He refused to allow me to hire a lawyer for my LLCs. See attached transcript. We'll see whatever she attached in a moment, but no one refused to allow her to hire a lawyer. She didn't make a motion for a lawyer and then had that motion denied or something. She just never did it. I will follow this up with a formal motion and compendium, and the assistance of counsel, if Durkin Peacock have not added another 100,000 in legal fees. It's done. It's over. It got paid. It's marked satisfied. You'll see in a moment. I am disgusted with Chicago's judicial system and the citation to discover assets that they will send to anyone who needs to pay you and then make a deal with them. We had a 10-year relationship, not pay us since June. Again, no names or details. Please let Judge Durkin know that after waiting for hours at 7 a.m. Eastern Time, I did not hear our case, nor was it listed on the docket. Was the minute order entered before the hearing, just like the $58,000 paid to Peacock was signed before the hearing? I implore you to have that turnover order canceled and a hearing held. This does not sound like a motion to reconsider the turnover order or a motion to vacate the order or any sort of court motion. This sounds like the rantings of someone who does not represent Malibu Media as a legal party, as a legal representative. She may be the proprietor, but she needs to have a lawyer represent Malibu Media, and she has not done that. A judge is an officer of court, so are attorneys. State judge is a state judicial officer. Okay, this is starting to get into that sovereign citizen stuff that we've heard from her before. Whenever any officer of the court commits fraud during a proceeding in the court, he or she is engaged in fraud upon the court. Yeah, we've seen this before. This is Colette's sovereign citizen language here. Fraud upon the court makes void the orders and judgments of that court. The thing is, in order to get it ruled as fraud upon the court, she has to go to another court and ask them to rule on it, so she has to go to the appeals court. How much do you want to bet that she has no idea how to timely appeal, nor is she willing to or able to pay an attorney to timely appeal for her? Federal law requires the automatic disqualification of a federal judge under certain circumstances. Those include impartiality, state of mind, conclusion that a fair and impartial hearing is unlikely. I think she's trying to get the judge disqualified in the most lame attempt possible. Then she talks about recusal. Judges do not have discretion to disqualify themselves. Great. Where's the... Connect the dots for me, Colette. Connect the dots. And that's it. I think she just stops there. If you were a non-represented litigant, and should the court not follow the law as to non-represented litigants, then the judge has expressed an appearance of partiality, and under the law, it would seem that he or she has disqualified him or herself. However, since not all judges keep up to date on the law, and since not all judges follow the law, it is possible that a judge may not know that the ruling of the Supreme Court and the other courts in the subject. Wait, what ruling of the Supreme Court? Either way, what she attached then is the August 20th notice from Joe Stewart, William Mullins' collection attorney, to Colette and Brigham. Ms. Pellissier, whatever the below be characterized, an offer or bid, it is rejected out of hand as not conforming to Mullins' previously articulated terms. So we can expect to see a settlement offer below. As much as my client would like to settle, we already laid out the terms in a previous email that I sent over a month ago and forwarded to you again today twice. Oh, and this was August 20th of 2021. So this was back when the judgment had been entered and the citation to discover assets had gone through, and we were in the beginning stages of Epoch having to turn over revenue to the Peacock Law Group. In short, the terms that must be offered by Malibu Media must contain all of the following: the current judgment amount, about $48,000, interest, about $2,000, costs, about $1,000 to $2,000, and attorney's fees incurred post-judgment, about $10,000 plus. Thus, when Malibu makes an offer conforming to our terms, we will respond. Moreover, as far as we can estimate, Zoe Digital and Mr. Field have received about $84,000 in funds. Those are funds that my client has a superior interest in because of his judgment. Thus, Mr. Field's offer is nothing but the proverbial sleeves off his vest, as Zoe and he legally must pay that money back to satisfy Mullins' unsatisfied judgment. Zoe and Field now virtually owe the entire judgment amount, including attorney's fees. Zoe and Field's liability will be reduced to judgment very quickly, within weeks. In that regard, I will remind you and Mr. Field that there is a certain Zoe Digital bank account that receives the weekly net receivables from Epoch. Whatever funds are in that account are also subject to the court's asset restraining order. I expect Ms. Pellissier to report to me on Monday about that account balance as of last Saturday when the asset restraining order was served on you and what the balance is on Monday. Remember, whoever transfers funds subject to the restraining order risks personal liability for that transferred amount and criminal contempt sanctions. So there's what she's talking about with the criminal contempt sanctions. If you have money that is being held in constructive trust, in other words, that revenue belonged to Mr. Mullins through the asset restraining order from the court ordering the assets to be held, then messing with those funds, taking those funds and transferring them to somebody else, refusing to turn them over, something like that, yeah, that could be either civil or criminal contempt. So he's not wrong there. Let's see what else this is. There's the information page about Judge Thomas M. Durkin's, looks like local rules or his local rules and courtroom procedures. I think she's showing that there's no hearing. Then she shares a docket bird notification. Brig Field has shared a docket sheet with you, Chicago abusive process. And it's just a docket printout. I think this is the case. So she's included a printout of the court docket from another Malibu Media case. Oh, it's this one. It's the William Mullins case. So just, include a printout of the docket to make sure that we get another 26 pages in here. Then there is no link to where this was from. This looks like sovereign citizen crap. When your opposing lawyer lies or submits falsified documents, since he is an officer of the court, this amounts to fraud upon the court and voids the whole proceeding. I don't think so. So there's a bunch of crap in here. And then she's filing things that are already filed on the court docket again. And then this is when she attempted to transfer something to Zoe Digital. Malibu Media hereby assigns Zoe Digital all of its rights, duties, and obligations. Yeah, so it looks like 2017 she tried to transfer all of her Malibu Media assets to Zoe Digital, probably in an attempt to hide assets, is the best I can think of what she was going through at the time. Here's the form that they have to fill out. She says that Zoe Digital has no property. Oh, Brigham Field says that they have no property of Malibu Media, even though she's included this assignment of contract. And then down here, the asset restraining order says, no, we don't have any property that belongs to Malibu Media. More asset restraining stuff. So the good news then is that is the end of the case. Joseph Stewart finally filed a satisfaction of judgment and release of liens. The $48,656 was paid, the $59,614 was paid, and that's it. The judge then enters the satisfaction of judgment, and that should be the end of the case. It's a crazy, crazy world. This was a company that was easily making over $10 million a year. I have heard reports from anonymous sources that it was up to about $20-some million per year that Malibu Media was making off of their BitTorrent file sharing. I'm calling it an extortion scheme, but it's not an extortion scheme because extortion would be if you got something and you didn't have the right to make the claim. But Malibu had the color of a claim. They claimed to have seen copyright infringement via BitTorrent on the internet, on the Pirate Bay, and they claim to have tracked that back to an IP address. So they have some kind of color of law. And that's the thing that I never agreed with, that you could sue somebody successfully without being able to identify them as the individual infringer. What the court process appears to allow is that you file an initial suit, you make the pleading and the complaint, the short, plain statement of the facts, a statement of jurisdiction, a claim for relief, and then the court process, the Federal Rules of Civil Procedure, will allow subpoenas, will allow discovery of evidence, will allow depositions of witnesses under oath, will allow the discovery of electronically stored information on computer drives and cloud drives and things like that. That can then be used to identify an individual infringer. And that's what I always had a problem with Malibu Media. I think they had to have stronger evidence before filing the complaint. Initially, they felt that filing on a threadbare of evidence and then getting into the discovery process was the right way to go. And so far, Malibu and Strike 3, they still had the ability to do that the last time I looked. Malibu just hasn't been operating properly because of whatever's going on with Colette and Brigham and their personal and business lives. So yeah, that's a crazy way for a court case to start and then a massive copyright litigation effort to just end because of mismanagement. But that's what's going on. Let me know what you think of this craziness in the comments below. Thanks for watching. Special thanks to my top supporters in May: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, Gutbrodj, ShadowTycho, Earthbound Star, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsus.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.